Folks, I think we're ready to get started. My name's Bill Fee. I'm a trial judge from Angola, Indiana, and I'm quite honored to be the president-elect of the Association of Family and Conciliation. And now it's my great honor to introduce the AFCC president, Mary Ferder. Mary is, as you know, a family law attorney from Boston, Massachusetts.
Well, and the debates continue this morning. We had last night's debate over whether the model standards are a help or a hindrance. And today we're going to look at the realistic approach as to whether or not these comprehensive model standards are something that families can afford. And if they can't afford, what are our options? And on the other hand, do all judges and lawyers and families need comprehensive custody evaluation? Again, we have moderator Arnie Scheinvold. Arnie is a psychologist, custody evaluator, and mediator. He's a member of the AFCC Task Force on Model Standards for Child Custody Evaluations. And then we have Sam Ferrara, attorney in private practice in the metropolitan New York area, and he specializes in family law. Next to Sam is Nancy Olson, who is a psychologist and custody evaluator in private practice in Northern California. Next is Clarence Kramer, who is the Director of Family Services of the Conciliation Court in Arizona. He also does, in private practice, does some child custody evaluations. And then, last but not least, is our President-elect of AFCC, Bill Fee, who is a trial court judge in Angola, Indiana.
You're involved in a custody litigation, and you kind of have to decide about what your strategy is going to be. How do you decide if and when you would like to obtain a custody evaluation, and what kind of process?
The first and primary piece of analysis that we do in my office is, and it doesn't always square, I guess, with how other people practice, is we're going to make a determination financially what sort of resources this particular family has in triaging our representation. We have a range of clientele that come through the door from, what I'll term very loosely as middle class folks who have two working parents who are striving to make ends meet, to people on the very upper end of the economic scale who, don't have a worry in the world in theory economically. Once we make a determination as to what their economic resources are, and sort of hand in hand with that, I'm going to make a decision as to whether or not, in my heart of hearts or in my professional analysis, I truly believe that there's a custody issue here. When I get to that point, then I'm going to explain to my client and my client's support system, whether it's mom and dad, whether it's brothers and sisters, whether it's boyfriends and girlfriends, whatever the situation might be, here's how the process goes, here are the costs attendant to it. If you're really going to go down this particular road, there are certain things that I, as the professional who's representing you, am going to need. And primary in those, assuming that it's truly a custody battle, assuming that they have the financial wherewithal to do it, I'm then going to tell them that I'm not going to try a custody case without a custody evaluation and or a forensic expert involved in the case on some level.
Okay. So you've already started to frame for us in the way that you have kind of presented this, that from the clientele that you deal with, cost is going to be certainly part of the driving strategy here.
I framed it for you on purpose, Arnie.
Well, we've stopped you there. That's good. Good. And you did well in framing it for us. Nancy, Sam's kind of involved in this case, and he's decided that he needs evaluations. He has gotten the other side to agree that. The court has ordered the evaluation. Why don't you tell us a little bit about doing a comprehensive evaluation, especially in light of our model standards, and especially with respect to time parameters and the relative costs of this whole thing?
Well, I would accept an appointment to do a custody evaluation as a comprehensive custody evaluation. Those are the kinds I get and what I do. That's going to involve maybe 50 hours of work, counting that I don't count all the time I spend writing. There'll be a report that'll be somewhere between 35 and 50 or 60 pages long, and it'll take 3 or 4 months and cost somewhere between $6,000 and $12,000.
Mm-hmm.
For that kind of money, you're hired in my jurisdiction.
And I should raise my fees or move to Metro New York. I don't know.
So the $6,000 or $12,000 that Nancy just mentioned is kind of low for what you see?
To use the term a comprehensive custody evaluation, as we've sort of talked about, $6,000 to $12,000 would be something that I wouldn't, if a client has the wherewithal, and please just take it at face value, folks, we're enrolled. If a client has the wherewithal to come through the door to retain the firm that I work with, a $6,000 to $12,000 custody evaluation shouldn't be breaking the bank if custody is truly their issue. Where we come, in that area, a $6,000 to $12,000 custody evaluation falls on the low end of what the mental health professionals that we're dealing with a lot of times are charging. And I would be ecstatic to hear somebody tell me that they're putting in a 50-hour work on an evaluation exclusive of writing. Because if I got 50 hours in a custody evaluation that cost me that kind of money, that means I should have a real meaty report to work with one way or the other.
So how many of you are moving to New York soon? Sorry. Okay. Do you want to just really briefly for us, Nancy, when we talk comprehensive custody evaluation, what components are we putting into this?
I'm talking about interviews with the parents. That would probably be 4 to 6 hours with each of them. Home visits, observing the child with the parents and whoever else lives in the home, step-parents or grandparents or whoever else is there. It would include seeing the children alone in my office, seeing them with each parent in my office, probably, but not always, doing psychological testing with each parent and children who are old enough to do it. It would include contacting all the collaterals that have information, that is pediatricians and teachers and daycare providers and whoever else has information that might be relevant and useful to the process. It would include reading documents, previous pleadings, declarations, police reports, hospital, talking to therapists, if any of the people have them or have had them in the recent past, and then trying to put all that together into a report.
Okay. Bill, now the judge comes into play here. So you're the judge on a contested custody case. How do you get involved in the process? Do you simply wait for the attorneys to ask for an order? Do you ever initiate it? Do you order a specific type of evaluation?
Okay. So let me take the last question first. The answer is going to be always, it depends. It's going to depend on the factors that are present. What I try to do with cases is not wait until an attorney has brought the case to my attention or told me that they want an evaluation, because I might be waiting a very long time. And I have very early expedited hearings, and I try to get a handle on some of these issues. They might turn out to be settlement conferences. They might be very short narrative-type hearings where parties waive rules of evidence, but we need not get into that. I guess the point is that early on, I want to know if that's where we're going with the case. And there are a couple reasons. One is I want to really explore the other options, the cooperative approaches, and make sure those are fully aired out and vetted. But I also want to know, and Sam touched on this, is it really about custody? Is it about some secondary other issue that might be more narrowly investigated? And if that's the circumstances, I really don't need a comprehensive evaluation. I need something less than that if I can't get the parties to work it out in mediation. So, and of course cost is going to be a factor. I mean, the kind of money that is being talked about, even in Nancy's jurisdiction, would be problematic for most of the cases that I see anyway. And that's not even getting into the pro se population of cases. So it depends. There are various factors, and that's, I suppose you're doing the judicial neutrality tap dance up here, but I think it's important to be specific about what we're really after and not just throw everything toward an evaluation.
Can I ask a question, Ernie?
Can you ask a question?
Yeah,
Yes.
question.
Yeah.
How do you, that's the first part of the question. I'm a lawyer, multiple parts. How do you make the determination, Judge, when your lawyers come in before you to advocate on behalf of their clients. What criteria are you using to establish whether or not that early on in a case, a custody evaluation from your mind is going to be necessary or not?
Yeah.
I'm interested.
Well, I want to know what is the crux of the custody issue. Are we really talking about child custody and parenting time split? Are we talking about is it a property division issue in the guise of a custody case? Are there psychological issues that need to be explored that are troublesome to one parent and really need to be nailed down and established by a psych eval? So those are the kind of things I want to hear about from the attorneys. And
Would it make a difference if you didn't have a mediation?
That's two questions.
ability? I know, but I need to hear this because we don't have mediation. We don't have the mandatory mediation resources, as many people know, in the New York family law areas. So I'm curious, if you didn't have the ability to put them out into mediation to help flesh out the answer to that question, would you be handling it differently?
I think I'm probably not any different than most judges. I want to have an eval if I can get one. And we're going to talk about the notion of what that does to the system in terms of conserving resources. So the incentive is certainly there to say, okay, you folks are getting an evaluation, tell your clients this is the way we're going to split the cost of it because there are these resources on this side or that side, I might apportion the cost. But I would tell them they're having an evaluation if we're going to go to a contested hearing. And I think most judges would probably handle it the same way.
Okay. Clarence, I'm going to ask you to answer one of the parts of Sam's question, but in addition to that, so you get a referral for a comprehensive custody evaluation in your court system. What does that mean to you? You ready to charge people $20,000?
You bet. I just
You're
quit
gonna
the court
get it?
system.
You're going to get it?
Well, first of all, we're not going to get a referral for a comprehensive custody evaluation. Our system's set up so the judge only has one choice to check a box that says it's referred for dispute resolution and assessment. And then the clinician will make a determination with the clients whether this is confidential mediation or non-confidential dispute resolution and assessment, which could turn into a full custody evaluation, but it's the clinician that's making that decision.
So does your court service have the time to offer what Nancy's talking about in terms of custody evaluation?
No.
So obviously your clients don't get the Cadillac, huh?
No, Subarus.
They get Subarus.
Or was it the Yugo? I forget which.
Yugos.
Very few of them do because we're so backlogged. The ones that we do have to do the comprehensives on, it just takes up so much time and resources that we can't do too many of them.
So if I understand the way you've explained the way your jurisdiction works, Clarence, no disrespect, Judge, but it sounds to me like what your judge does is when a contested proceeding comes before the judge checks a box and throws it out to you to make the initial determination that Bill was talking about earlier.
Correct, because we do have a rule or state family law that states if there is a controversy over custody visitation, it must go to, and that could be either mandatory mediation, but ours is unique in the sense that it's more of a triage program.
But in determining whether there'll be a comprehensive evaluation or something more or less, where in Bill's jurisdiction, he's making that call. In my jurisdiction, the lawyers are advocating on one side or the other for it. In your jurisdiction, the judge is sending it to you to make that determination?
Mm-hmm.
So what do you do, Sam? And I'd like to remind my panelists here to please get close to the mics and talk into the mic so they can hear these comments. That's better. That's good. So what do you do if there's need for this comprehensive custody evaluation, and you really need this because there's a real issue around relative parenting capacities and that sort of thing, but your client can't afford it?
It's not an option, without being too smart-alecky about it. As a lawyer, my job is to advocate on behalf of my client. If my client tells me, or I make an analysis that there is really a custody issue here, there's an issue over parenting capacity or domestic violence or something else that's beyond the tangential issues of who's going to get to live in the house or who has to pay child support or something along those lines, then I have to have a heart-to-heart with my client and say, I'm not trying a custody case without a mental health professional expert on my side. Whether or not that's a court-appointed, neutral evaluator that they're going to have to pay for, or whether it's somebody that I'm hiring privately, it's not an option. And, you know, in the earlier part of our preparation, you asked me a question, you know, what if the judge orders it based upon my advocacy and apportions the fee? What happens if they don't have the money? It's not an option. You go find the money. If you're going to fight a custody battle and you're going to have a comprehensive evaluation or forensic expert, you've got to go find the money. And, you know, this leads to, you know, if you're walking through the door to my law office, you've certainly got resources somewhere, because we don't come cheap. And if it means that, you know, you're not going to be driving your Cadillac and you're going to have to drive a Ford Taurus, then, you know, that's a decision you have to make. But I'm not trying the case without it.
Huh. So,
Apparently there's some commentary.
Bill and Clarence, what's your reaction to that?
Well,
I guess my initial reaction is you know, there's a line to be walked here in the sense that, you know, you, as a judge, you want to be sensitive to access to justice issues and who can play and who can't play, and because they are there, they are real in the system. But you also have to be aware that that there is a cost associated with fighting over the custody of children, and the monetary cost is the least of those costs. So I think on the other side of the argument, it brings home to the parents the notion of what it really takes to go to court and fight over custody, that this is real, and you may have to sell that interest in the condo, your vacation condo. You may have to do something else. Dad may have to give up his vintage Harley motorcycle. Something like that might have to happen, and there's a certain reordering of priorities. On the other side of that argument, this is where Clarence and I have some difference in terms of our jurisdictions, is that he's heading up a court-connected program. I'm without a court-connected program, and I recognize that there's a vast population of cases where there just aren't resources. There really, truly aren't resources, and we do the best we can with what we've got, and we end up handling the cases the old-fashioned way. We litigate them.
Okay.
Arnie, can I respond to that?
No, yes, you can. Go ahead.
Which one does he mean? And I think what Sam says about they have to go out and find the resources is what's happening in Arizona now. I don't know if you've been following the news, but recently there's been a real rash of people stealing forklifts and then taking ATM machines. And those have been ordered for custody evaluations, and they're finding the resources.
Well,
But if the resources aren't there, I don't think our clients are perhaps as middle income as what Sam's describing. They're not going to have them. They're not going to have the Harley. They're not going to have the vacation condo. They're not going to have a lot of things. And I think what we compensate by doing, or what some judges do, is appointing a best interest attorney, which is a lot cheaper than getting a comprehensive custody evaluation.
I want to break in with a comment about false economy, because there are a number of cases that have been ordered to family court services where I am in California for a, quote, full evaluation. Family court services, not having the resources, does essentially recommending mediation, plus they interview the kids for 15 minutes each. So you've got an hour and a half with each parent and 15 minutes with each kid, an 8 or 10 page report in which everything both parents have said is reported to the court as truth, and a recommendation is made. But the mediator can't be cross-examined on it because she's not an expert, and the file can't be discovered. So there's a trial without any of the information. And I'll tell you what happens and where the money goes. There's now $50,000 in attorney's fees and expert witnesses who are hired to actually look into the information that a custody evaluator would have done. So in order to save the, say, $20,000, they've now spent $75,000. Because they have to try to undo what has been incompetently done. So my argument about a full evaluation is that it's sometimes cheaper. It sometimes leads to settlement. It prevents a trial. It can, in fact, provide the information that is needed to save a lot of money downstream. So that I think you're talking about a false economy when you go to at least a badly done brief evaluation. We can talk about whether there's some other thing, but currently what we're up against where I'm practicing, which I don't think anybody is here from there, are really bad. They're pretending they have evaluations when they don't.
If I could, real quick on that.
This is what I meant about lack of control. This is just kind of go here.
Could you be quiet, Arnie? I'm talking. One of the most important things that I think Nancy said, and I think Bill alluded to it a little bit earlier, and I didn't express it for role-playing purposes. When I'm sitting down with a client, you said to me, do I need a comprehensive evaluation? It's a real good tool for me to say to a client or a judge, knowing that there are not resources or there are limited resources, to say, this custody case is not going to be effectively handled without a custody evaluation that is going to cost you and your spouse or you and the other parent X tens of thousands of dollars, which you may better be spent on your kid's college education or paying off that second mortgage so you can afford a second home in this reorganizing family. So while we're advocating on both sides of the equation, let's not lose sight of the fact that the necessity of a comprehensive evaluation can be a very useful tool. 90+% of custody cases do settle themselves. And the flip side to that argument is that oftentimes spending $15,000 or $20,000, and that's on the high end kind of sometimes, not that often, $15,000 to $20,000 on a custody evaluation can save the litigants $50,000 or $100,000 in a full-blown custody trial, because if the custody evaluation is done properly, both parents can have a measure of confidence in what was done, which in turn gives the advocates, the lawyers, an ability to use it to help settle the case.
Can I just say one thing, just kind of in response to that argument? I'm sorry. The notion of the false economy, that is entirely dependent on the idea that there are yet again additional resources beyond the initial amount of money that the parties have to spend on this ongoing dispute. And we may just be talking about entirely different clienteles or populations, but the $12,000 to $15,000 to $20,000 definitely, those kind of evaluations would pretty much exhaust 80%, 85%, 90% of the cases that I'm going to see. So, and that doesn't even address the issue of there's an awful lot of settlement value in lesser reports. I'm not being pejorative, but if I appoint a GAL or a CASA and they give me an investigation type report and there are some recommendations tagged on to the end, that report is still very valuable. And experience tells me that it does help settle cases, it does narrow issues, and it does bring the parties to a point where they're in a better position to settle a case.
Well,
Go ahead, Arnie.
Is there any time for me?
Arnie, do you have anything to add?
No, but I do have a question, because one of the things that starts coming up here is somebody used the term a tool, that the comprehensive custody evaluation can be a tool. But it sounds like, in terms of tools, that some people get to be able to buy a backhoe and somebody else has to try to use a fork to dig the same hole. So my question is that fair in the sense that the court may ask someone to either pay for a backhoe when they don't have the resources to pay for it, or just in general that we expect a certain group of people to have to deal with their problems with tools that may not be adequate?
Good question.
Well, answer it.
What do you think about that? In the law, we do have all kinds of minimum competency thresholds. The standard practice for an attorney, what's competent for practice in criminal defense, what's reversible error, what's not. There isn't any reason why we shouldn't have the same kind of guidelines and standards for custody evaluations. Does every evaluation have to run the gamut of all of the, I think it was Mary last night referred to the 250 affirmative statements? No. I mean, it doesn't. What does have to happen, I think, is that the considerations that are in different parts of the model standards regarding due process and fairness, those need to be observed. And when they're not, they're, I think, fair game. So.
And I agree with my esteemed colleague here. I think if you have to dig a hole, you can do it a lot quicker with a backhoe than you can with a fork. So I think in an ideal world, everyone would have the backhoe to dig their own hole. See me later.
Yeah, well, some analogies work better than others. I want to say something about what the dangers are in really brief evaluations. And that is that it's very easy for the person doing the brief evaluation to make a snap judgment based on a first impression of how somebody comes across. It's very easy to give generic opinions. Kids need to see both parents. Not does this particular specific child need to see this, have this amount of time with this particular parent. And I think people believe they can tell who's telling the truth. And all of the research proves that we are no better than chance at telling who is telling the truth. But evaluators, we're trained. Everybody thinks, hey, I'm good at it. My clinical skills will let me know who's telling the truth, which I don't actually believe. And I think that people can misattribute the causes of certain behaviors. If a child is behaving in X way, and mom says the reason that the child is, not sleeping or whatever is because of dad, it's very easy to take that at face value and not dig any deeper because it takes more time to dig deeper. So there were a lot of dangers with the short evaluations, and I think you're right, people don't have the resources to question them, so you just get decisions based on them, and maybe they're right and maybe they're wrong, but it would be cheaper to flip a coin. If you're going to not have the information you need to make a decision, why go through the pretense of having something which I think of as a kind of fake evaluation?
And I'm going to, thank you, Arnie, I'm going to disagree with that. Not that that doesn't happen, but that it doesn't have to happen, because there are jurisdictions that do what they call focused evaluations, where they're going to focus on the specific issues, and they're not going to do a comprehensive evaluation, and it's not necessary.
And they're not going to pretend they're doing what?
Except that, Clarence, except that the premise, and let me say for the recorded record, that I agree with Clarence's concept. As a practicing attorney who deals with the difficulties of the economics of the situation, the difficulties of evaluating the custody component, and actually trying the cases, I couldn't agree more. Having said that, I now raise the question of who has an ability to make the determination of how that evaluation should be focused, and once the evaluation is focused, ensuring that the evaluation is held to the same level of competence or the same standards as this comprehensive evaluation that we've all been talking about. In New York, as an anecdotal piece of information, thanks to the good work of some of the people who have presented before the AFCC in the past, many of the judges that we deal with no longer allow a forensic evaluation in a custody case to set forth recommendations. The judge takes a framework and incorporates the framework into an order and says, the forensic evaluator shall do the following. They shall evaluate the relationship between the parents and the children. They shall look into the psychopathology. They shall look into A, B, C, and D. And there's a very specific paragraph contained within the orders these days that say, under no circumstances shall the evaluator make a recommendation as to custody and visitation or time sharing.
That's great for liability.
Okay, I guess we have Tippins and Whitman coming in tomorrow with Nick Ballard to talk to us about, to debate the idea of recommendations, although what I hear you saying is that the expectation is that every step of the comprehensive evaluation is going to be done. They're just not going to, in the concluding paragraphs, say whether or not, what they recommend, what the ultimate decision ought to be. That's not going to save anybody any money, is it? Or time.
You actually asked a good question, Arnie.
You allowed me to get one in.
The purpose of my response to Clarence, to shift the focus a bit, is I guess you're probably not wrong. It may not save any time and money, maybe. In fact, it may cause more time and money because without the recommendations, you're now throwing it squarely back in the judge's lap and or the respective attorney's laps. But it still begs the question that, sorry, Bill, that the judge has now thrown this thing into the forensic evaluator's lap instead of, does the forensic evaluator really need to look into all of the collaterals if the issue is that one party or the other may have some mental health difficulties, i.e. a bipolar issue or something like that? Is that, is there some way to narrow the issue in that regard? Is there a domestic violence thing going on here? Rather than spending all of this money to answer all of the comprehensive questions. Is there a need for psychological testing in this particular case, or will the fact gathering that a custody evaluator might be able to do, I use the term fact gathering a little bit loosely, but in terms of identifying the relationships and evaluating the parenting skills and so forth, that's really where it's most useful to me in terms of getting that comprehensive custody evaluation, because those are the things that I use when I'm on trial.
So, Bill, when we were talking earlier, you said, almost in response to that type of commentary, oh, we'll go back to doing it the old-fashioned way. Can you expand on that a little bit as to what you meant?
Well, yeah, sure. Ultimately, cases are going to be decided. One way or the other, they will be decided, and there is always the possibility of litigation at the end of the process. That's the end stage. And the whole idea is to try to settle the case if we can. It's better for all the reasons we all know about. If we can't, to have the best information available to the judge. I don't have any problem with standards. I think standards are great. I voted for the standards at the last board meeting. There is an irony here if we say that now, because we have these standards, that nothing less than will be permitted in court. And there's an unintended consequence because there's less information then going to the judge, the fact finder, when there just aren't the resources for the comprehensive evaluation, or as Clarence was pointing out, I think Sam was getting there, that the resources have been misdirected in an overblown, unnecessary evaluation when they could be spent better elsewhere. So I think it's, I would take issue a little bit with Nancy on this notion that that these other evaluations or recommendations are necessarily not good, because as a judge, and particularly a judge from a rural county where resources are an issue, I don't have a court-connected program, I want as much information as possible. And then we'll leave it to the fact-finding process to sort it out, what's credible, what's not credible, what's supported, what's not supported. And by the way, if that report leads the parents to, at the courthouse steps, settle the case, they're still the parents. And they're still making judgments about their children, and they can look at the report, they have attorneys, they can evaluate whether the report is up to snuff or not. There's still a value there that is very important.
Well, but there's a paradox for an AFCC member in that, because if AFCC has defined a standard for an evaluation that leads to a comparison of relative parenting strengths of the parents, which may lead into a recommendation or certainly the inference of close to a recommendation, then what else can Nancy answer other than to say anything short of that that's leading to a recommendation is inadequate? I mean, you seem to be saying, well, it's better to have the inadequate thing than to have...
Well, yeah, and I'm not an evaluator, and she's not a judge. I'm speaking from my perspective, and I'm telling you that in terms of how I'm looking at a case, I'm going to use every club in my golf bag to try to,
Back to those analogies again.
Yeah, the sports analogies and the car analogies are really not resonating in this room very well. But different perspectives. Yeah.
Arnie, and I'm going to identify, even though Nancy and I are kind of on the same side of the proverbial debate, I'm not sure, and I'm not an evaluator, I'm a lawyer, but I'm not sure that the shortcomings that Nancy's identifying don't also come into play with a comprehensive evaluation, because you're taking these folks, listen, I don't need to go on and on about the difficulties with custody evaluations, but you're taking these folks at a snapshot in time when they're both advocating, for the same thing at the same point in time. Granted, the more time you spend with people, perhaps you're reducing that margin of error, but I'm not sure that you're necessarily taking away, some of the problems with these, I guess you call them short, or you used a more pejorative term. Let's see, I learned.
Well, I would assume, though, as a good trial attorney, you would certainly rather see somebody come in with, especially if you have a recommendation against your client, you would certainly rather have somebody, that expert, come in on the kind of brief, short evaluation kind of side that you have a lot more fodder to cross-examine.
Candidly speaking, I'm not sure, and I'm not playing, dodge the question with you, Arnie. I'm not sure. It would depend upon the evaluation. Sometimes, you know what, the more comprehensive the evaluation, the more I have to work with. And a short evaluation is riffed with all of the abilities to say, I didn't have the resources to do this, or we didn't get to that, or I limited it to this particular issue. So, yeah, it might give me an ability to put some words into my expert's mouth, but in terms of pure cross-examination, sometimes a comprehensive report I can have a lot more fun with.
Okay.
That it may not depend so much on is the conflict that high, but are the questions that difficult? And when the questions have to do with sexual abuse or domestic violence or serious mental health issues, I think you're in a different category than, a settlement instrument for working with the people to move them.
One of the points of this discussion, though, is not that there are other types of processes available for families. There are. There's mediation, there's parent coordination, there's all sorts of triaging in between hybrid steps. But the question is whether comprehensive custody evaluations are the standard by which these more broad-based questions need to be answered, and whether or not there's a real issue of access and access to justice within that. Because one of the things I hear, and I do want you all to respond to for me after we hear some more questions, is we've even gotten to the point where we're willing to have local court rules changed to allow inadequate information to enter unchallenged because of this recognition that maybe it's not the best system, but it's what we got. I mean, when I hear that an examiner can't be cross-examined, that's quite a difference in due process. That's quite a difference in rule. And have we done that because the information's so good? So over there.
In Georgia, the courts are less than creative, and I was just curious in your area if the judges and the system, as a matter of fact, seems to encourage battle. I was wondering if in your areas there's any kind of creative process, like perhaps taking the kids away from both parents so they'll learn to communicate for a short period of time, not like for a year or 13, but like for a month or so they'll focus on what's really important, and then cut through the chase and get rid of most of this expense in battle. So I was curious what y'all had to say about that.
Clarence, how many kids do you have living in your house now?
17.
17. And Bill?
Yeah, 21. No, that's the extreme notion that you would even go there. But in Indiana, there is a notion of third-party custody, and if there's that interested person who wants to step into the middle of that kind of chaos, could file a pleading, but you certainly don't want to become, a placement agency for children when what we're talking about is trying to develop healthy families. Sometimes there aren't good choices. That's true.
A lot of times that's called grandparents.
Yeah, a lot of times it's called grandparents.
Well, short of it becoming a dependency case, even within that type of suggestion, how is that evaluation going to be made? Is it going to be made in some brief format? Is it going to be made in a comprehensive format? And oftentimes, and with the families that might need that, do they need the more comprehensive, or is it real easy to decide?
Well, it's an interesting question that's raised, and for the benefit of my colleague from New York, I actually don't handle all high-end cases. A judge, and I'm going to refer to the judge as a cowboy, in Suffolk County, which is the eastern end of Long Island, is known for making those sorts of decisions off the cuff from the bench. And what he does is, in a particular case that I became involved with after the fact, because I was so upset by what took place, he effectively took what they call an O docket, a family offense, on a simple, non-physical domestic incident for an order of protection, and sua sponte, within the context of the hearing, between 11 a.m. and 2 p.m., when he broke for lunch, he turned it into what's called an N, or a neglect petition, took the child from both parents, and threw the kid with an aunt who one of the parents happened to have with them as a support system. The boy, the child in that particular case, stayed with the aunt for a little less than a year, during which time I became involved in the case, and ultimately, to your credit for your suggestion, and the reason I'm telling the story, ultimately the child was returned to the parents, and the parents kind of got it. And for the past couple of years, I'm not going to tell you they're perfect parents because they're both knuckleheads, okay? But they're not in the court system. They're learning or relearning or using whatever limited communication skills they have. But that's a unique situation because you're raising a host of other problems that I think Arnie raised in jest. You know, where are you going to put these kids? You know, what are you going to do with them? And how do you revert, if you make a mistake, how do you reverse that mistake? You've just plucked a child from two parents and thrown them someplace else. I mean, it's a risky proposition, and it's not one that I'm real comfortable with as a lawyer, as a parent, or as a human being. So while I've seen it work in a limited circumstance, I can give you another story where it didn't work.
Okay.
Mark Benjamin, Minnesota. Two questions. One for Clarence. To the extent that we've been discussing the financing of the custody studies, what message does it send to you if a parent with no resources of their own is able to get resources from the extended family, the grandparents, the aunts and uncles, and so forth, that would indicate either a positive or negative message to you? And the second question for the panel is, to the extent that the custody studies are designed to help settle cases, should the evaluator be available for Q&A with the attorneys post-report and or the parties themselves?
Why don't you take the first,
Yeah, you take the
Clarence,
first
and
one.
maybe you want to take
Yeah.
the second, man.
I think the message it sends to me, based on experience, is it's not necessarily good. It's usually a grandparent in there who is meddling, financing it all, providing funds for the attorney, wanting custody of the child, or the grandparent's child will get custody of the grandchild. I think it can be good when the resources are available, especially if the other one side has them, the other side doesn't, when the extended family would provide those resources. But experience-wise, it's usually somebody meddling in the case.
Okay.
And for the second part of the question, I absolutely think that the evaluator should be available to both attorneys. And it's in our local rules of court that it's the expectation that the evaluator will show up for the settlement conference, which we have mandatory before you can go to trial. There is a settlement conference, which is where, I mean, some of them settle before that, but we have to show up and be prepared to discuss all the back and forth about which part of it are they going to settle it, if so, what's it going to look like, and it's often very helpful to have the evaluator there.
And I will tell you that I wish that we had that, because most of the orders directing custody evaluations will contain a provision that specifically states that the lawyers are not supposed to talk to the evaluator. And the evaluator is not supposed to contact the lawyers or the judge until there's a final report or if they have a specific question. But in New York, in the jurisdictions that I practice in, which comprise the metro New York area, the mental health professionals, the custody evaluators, aren't participants in the settlement negotiations or conferences, other than to the extent where, you know, during the evaluation process, they might throw out the, well, how do you feel about joint custody? Or what do you think the role of the other parent should be, which will be reflected in the report for the lawyers to use. But as a practitioner, I can't imagine a scenario where in the greater good, in the greater good theme, that having the evaluator present for a settlement discussion wouldn't be tremendous.
Just to be really clear, it's after the report's done. Okay.
I want to ask a question that hypothetically, if money were not the issue, we're all paid from some other resource, so evaluations are free.
Clarence?
Are comprehensive evaluations the gold standard? In fact, is that what we would wish or think is best for everyone? Or is it more like doing open heart surgery when an echocardiogram might have sufficed? And how would we decide that?
Who wants to take that? Clarence, go ahead.
I can chime in to say that I think it could be the gold standard, but I don't think it's for everybody. I don't think it's fair to involve children to such an extent in an evaluation process if it's not really necessary.
And I agree with that absolutely. I don't think a comprehensive evaluation is needed in maybe most cases. I think there's a lot that can be done without a comprehensive evaluation. I just think if you do need one, then you need to have a real one.
Welcome to our side of the argument, Nancy.
Well, that's what keeps happening.
And I would comment that
I didn't get a chance yet, Arnie.
That's why I'm going. My comment to that would be that obviously it depends on what the question is, and that there are all sorts of steps, processes, and other types of evaluations that can help with certain questions that are being raised. Again, my concern is that when the questions being raised need a comprehensive evaluation, what happens for those people who don't have access to it? And what got raised today, and we haven't gotten an answer to that yet, is it seems to me not only are there changes in expectations and standards for those processes to come up with similar opinions, but even the court processes may be changed to allow them in. Nancy talked about these recommending mediations. I can tell you in Pennsylvania, there's a county in Pennsylvania where there is a process where an evaluation is done, which is somewhere between a focused and comprehensive evaluation, and by rule, the evaluator cannot be cross-examined, yet can testify. So
Yeah, everybody's going.
I could throw this out. When we do our dispute resolution assessment, they have to sign a stipulation not to subpoena us or our records. And they're screwing them for the due process.
yeah. So those are the type of things that we're talking about. Let's go from this side.
My question was going to be, I have a new one, that the panel had to promise to tell me the truth. You promise?
I make no promises.
I don't promise.
Do you believe you get what you pay for? But my question really is, can you, particularly...
With respect to us individually, for what we service, or on a broader question?
The question really is, how does somebody like me, Clarence, Phil, some of the court service managers in this room, convince the court, attorneys, rich evaluators, that our product is just as good, that you get what you pay for can be a false assumption?
Go ahead.
Well, if you get what you pay for, we don't charge anything, so you wouldn't be getting a whole lot. Yeah, and I know that. But I think that there are people who do better than what we do, and there are people who do not as good as we do, or not as well as we do. And I think that's just the reality of it. We focus our program to meet the needs with the resources that we have, and it's not ideal, but it's good.
I mean, I would just kill to have either of your services in my county, but that's not what I've got in my county. And I don't think it's all money dependent, because there are some evaluators who are doing very well indeed, who I think do kind of sloppy, shoddy work. So it's not that everybody who's doing expensive private evaluations is doing a wonderful job, and everybody who's doing brief evaluations is doing a terrible job. There are standards in between, and I think it's time for me to start shilling. The National Council of Juvenile and Family Court Judges has produced a judge's guide to navigating custody and visitation evaluations, which includes a lot of talk about what to do when there are no resources or when there are resources for partial, because the issue is finding what you need in a particular case and finding a way to get it. It's not ordering comprehensive custody evaluations for everybody. They have a table out there. Somebody stole they don't have the new printing of them. Somebody stole their display copy, and I'm donating this as a display copy so you can have a look at it. There are little cards the judge can have on the bench with, ideas and instructions.
They call them cheat sheets.
Do they? Yes, there's a person out there who will take an order for them. They're free. You can pass them out to your judges. Anyway, there are ways to look at and negotiate how to get resources directed in a way that's cost effective. But if you're going to say that a particular case needs a comprehensive custody evaluation, it needs to be competently done.
I don't think, from a lawyer's perspective, that the adage you get what you pay for, whether it's a custody evaluation, legal representation, or otherwise, bears a whole lot of weight across the spectrum. I don't think anybody in this room, including the woman from Brooklyn, is going to tell you that just because she works for legal services 3 days a week and they can't afford to pay her, she's any less skilled or competent than any one of her adversaries who represents a multi-million-dollar client out there. Might that multi-million-dollar client have the resources to go out and hire a private investigator or some fancy doc to tell them what they want? The answer is maybe, but I'm reasonably certain, knowing some of the talented lawyers who work for legal services where I'm at, that it's not going to make a whole lot of difference if they're good at what they do and they believe in what they do. And I'm not preaching, I'm telling you the way I believe it from the bottom of my heart. I know a lot of real expensive lawyers who, candidly, I wouldn't hire to do a real estate closing. So, and the same thing holds true with some of the custody evaluators I've dealt with over the years.
Yeah, I think we're all in agreement on this particular point. You get far more than what you pay for with most Court Connect programs, and the definition of a profession is that you do have a certain standard of performance and conduct and competence. And so whether it's practicing law, whether it's making judicial decisions, whether it's doing a custody evaluation, we aspire to the standards. We enforce the standards sometimes if there's an enforcement mechanism. We'll never have a system that puts everyone exactly at the same level. What we aspire to do is to make sure that there's a certain standard met, a standard of competence, and that's where we're coming from.
Thank you. My name is Sidney Horowitz, and following up on some of the previous comments that were made, and based on the great philosophy of Charlie the Tuna that asked the question, do you want tuna that looks good or tastes good? My question really goes back to the issue of having a open heart surgery for when you really needed a much more minor intervention. Is how much of what we're doing right now in terms of custody evaluation is driven by defensive practice? And that is knowing that there are hired guns out there who are going through evaluations to see, did you do all the things that could be done? I'm not sure whether that's a helpful practice or not. And so I wonder what the panel's opinion is about whether or not we're being forced into defensive practice as opposed to doing what we really can do to assist in the well-being of a child.
That goes to the gold standard comment that was made earlier. And the truth of the matter is, from my perspective, a comprehensive evaluation sometimes does more harm than good in a situation where it's not necessary, because it's raising questions and people are reading things about themselves and their relationship that may not be relevant to what's happening at that point in time. We can go through every one of the analogies piece by piece, but I think, at least from my view, I agree with most of the panelists that a mechanism to focus in the issues, I don't know that in your world as a mental health professional, if that's what you're doing, that it's being driven to defensive practices. Whether you take one small bite of a forensic evaluation and keep it focused, as Bill and Clarence have suggested, or whether you do the comprehensive, that you're not going to be held to the same level of competence that we strive for in the AFCC guidelines and anything else. If you do the right job, you're going to survive cross-examination from my perspective.
Well, I'm going to say I think there is a certain amount of defensive practice in it. There certainly is an awareness that if I do less than the standards call for, I'm going to be questioned and attacked and vulnerable to it. There is another selection process going on because my evaluations are expensive and are very thorough. I tend to get questions that are appropriate usually. I mean, there are people with more money than sense, and they can kind of keep these things going, but ordinarily I'm getting questions that are very complicated, that have to do with either very young children and move-aways, or have to do with child abuse and domestic violence, that are not obvious. And I think that in those cases, both defensively and ethically, I would feel like I needed to do everything that I could do to get at whatever information and truth I could get at. But I think there is the back of the mind thing that says, just like doctors run the extra test just to be sure so that they don't get accused of not having done everything, I think there is a way in which we can end up protecting ourselves by doing everything that's possible to do. Well, the other issue Arnie brought up earlier that I had a pretty violent reaction to but have been thinking more about was the notion of ought private custody evaluators who are getting the big bucks for some of their evaluations donate some pro bono. And my immediate reaction, I'm really curious to know what people, maybe before I give my reaction I should ask, but having said it was pretty violent.
She said it was violent.
Yeah, no one's thrown anything yet, but my feeling was I wasn't sure that I was prepared. I'm pretty sure I'm not prepared to donate 50 or 60 hours and all the stress and aggravation and risk. And the ones that would come in that guise are probably going to be the worst of the worst, because those are the ones that the court would be desperate to get somebody to do. Yeah, right, for Nancy Erickson. I was like, I'm just not willing to donate that. I am willing to donate something, and for a while we had a working system back in the old days when our family court services actually did evaluations. A bunch of us private evaluators were willing to donate once or twice a year, say, psych testing. If they had a mental health issue and they really needed an evaluation of I get one, does the guy have a thought disorder? Is that part of what the problem is? It's a pretty focused evaluation. I provide that information. The mediator who was working on the case puts it together with all the other information I'm not investigating. And I was willing to donate that. It's maybe 10, 12, 15 hours. I could donate 15 hours. I can't donate 60. So so the question Arnie was raising about should we have pro bono, maybe, but it would have to be organized in a particular way.
Volunteers. Some hands up here. Got some hands up. What's that? Okay.
Yeah, I'd like to just comment on that last point. In Vermont, where I live and practice, the family court judges expect custody evaluators to do some pro bono work. There's no written policy regarding this, but for custody evaluators who are in court regularly, whom the judges know will call upon us once a year perhaps, maybe 1 out of 20 evaluations that I do are pro bono. They do this very judiciously. They pick only those cases that where there really are no other resources, where everything's been exhausted, but that have great merit and are of great importance to the court. So in addition to doing a good public service, it also helps your standing in the courts to do this as well. So I think it's a great idea if you can afford the time to do that. And since we make our living, many of us doing this, that this is a good way to put something back.
Thanks.
I live in Ocala, Florida now, and I'm originally from Connecticut. Personally, I feel a tremendous ethical obligation to donate, to do pro bono work, and to make certain, to the degree that's possible, that all children are afforded equal representation under child custody evaluations. I personally donate a minimum of 1/3 of my time and income, and always have done that, which means I have to live very frugally. In the child custody evaluations, I'm with Nancy 1,000%. I don't believe, personally, when someone comes to me and says, well, this is just one issue, we're only talking about visitation here. Well, that's the whole issue. That's what every case is talking about. A certain level of visitation, a certain level of parenting time. I don't see how those core issues can be gotten to without looking at and investigating all of the collateral sources, all of the other things that are going on, because even when those of us who do minimum, I call it the Dr. Patch Adams school of his philosophy, which is you cannot do a 1-hour interview. You've got to spend time with these people, let them know that you're personally vested in their children, and this takes a minimum of a 2-hour initial interview. I just had a case where each parent was 3.5 hours, and follow-up. Generally, these parents are so grateful that you are taking this amount of time with them, even if they don't agree with what you have to say. There's a percentage that they realize you have their children's best interests at heart. So I think we've got to really think about the standards, how we're going to be able to meet those standards, and I personally do not believe those can be met in any brief situations.
Okay, 2 more.
Well, and I'll try. I just want to comment on Contra Costa County, California has had for a number of years a system like what was described in Vermont, in terms of everybody sharing in the giving back to pro bono or low fee evaluations, or giving to the community in some other ways, supervising interns or being a consultant to the courts, to the family court services in some level, or doing some teaching. And I think that those are all ways that we can do it. But in answer to your question, Arnie, about what can AFCC do to try to help, I would love to see perhaps maybe we do a survey of members of the custody evaluation people that are here, put it together, put it online in some way to potentially find out what the communities are doing, because we're going to get, 5 people commenting here, and there's maybe 150 to 200 people in this room, and if enough people respond, we can potentially see what the various options are that are out there for helping to meet the needs of the lower income families or the non-income families in communities, so that we can really see what the range of options might be, so that everybody can brainstorm and broaden the opportunities here. So that's my comment.
Thank you.